Donald Trump has just removed a message that may have revealed his most serious legal weakness so far. Because after the Epstein files were released and Trump responded, he quickly moved to wipe away what he had written. And this is no longer about partisan conflict, but about what happens when a person with enormous power senses that pressure is closing in from all sides. And from a prosecutorial viewpoint, this kind of behavior is highly revealing. On January 3, 2025, a federal court in the Southern District of New York made public nearly 1,000 pages of documents that had previously been sealed in the Jeffrey Epstein case. And these are not fresh accusations, but official court records, long-hidden testimony, and evidence that powerful figures hoped would never become public. Donald Trump's name appeared repeatedly throughout these materials, and it is important to understand their origin, because they come from a defamation lawsuit brought by Virginia Giuffre against Ghislaine Maxwell, a case that ended years ago while the supporting evidence, including depositions, witness accounts, and flight logs, remained sealed until now. For years, the public story was carefully simplified, suggesting Epstein merely had vague social ties to influential people and that Trump knew him casually. But what is not emphasized is that the newly released documents contain detailed claims placing Trump at Epstein's properties during periods when abuse was allegedly widespread and ongoing, referencing Mar-a-Lago, Manhattan, and overlapping schedules that any serious prosecutor would immediately notice. Trump's first move was to publish a statement on Truth Social, labeling the release a witch hunt and asserting that he had banned Epstein from Mar-a-Lago long ago, following his familiar strategy of deflection, rewriting the past, and attempting to dominate the narrative. But within hours, that post vanished entirely, not revised, but erased. From a legal perspective, this raises a crucial question. Why would someone eliminate their own denial? And the possible explanations are limited. Either his attorneys warned him the statement was legally dangerous, or it contained a claim that could be proven false, or he realized it created evidence suggesting awareness of wrongdoing. When someone with Trump's instinct for confrontation, who has publicly attacked judges, prosecutors, witnesses, the FBI, and the Justice Department, suddenly removes a message defending himself, it signals that something significant occurred privately. What is also being overlooked is why this document release carries such weight. Because the Southern District of New York is not a political institution, but one of the most powerful and aggressive prosecutorial offices in the country. And when it unseals records, it does so deliberately, not randomly. These files were made public because a federal judge determined that the public's right to know outweighed privacy concerns, a legal threshold that requires a finding that transparency serves justice, which indicates the court believes there is information within these documents that directly affects accountability for powerful individuals. When Trump's reaction is viewed alongside that ruling, a prosecutor would interpret the deleted post, much like destroyed evidence, as a sign of awareness and intent, showing that he understood something was wrong. If his connection to Epstein had truly been harmless, distant, and long past, there would have been no reason to erase a denial. Yet he did. And the most damaging part is that the act of deletion itself is now permanently documented. Screenshots remain, archives remain, and the digital record never truly disappears, which means Trump has just constructed the kind of chronological trail prosecutors dream of. On January 3rd, the documents were released. On the same day, Trump issued a denial, and on that same day, he erased it, creating what looks like real-time evidence of awareness and fear. To understand why this matters, we need to look closely at what these newly unsealed materials actually contain, because much of the coverage has avoided the details. The Giuffre versus Maxwell case includes sworn testimony from several witnesses who were questioned directly about Trump's presence at Epstein-related events and locations. One deposition explicitly places Trump at Mar-a-Lago during a gathering where underage girls were reportedly present, and the witness described Trump and Epstein as being notably close during that period. Another document refers to a deposition taken in 2016, in which a witness was asked about Trump's conduct at similar gatherings. Testimony that remained sealed until this month. Does this automatically prove criminal wrongdoing? On its own, no. But from a prosecutorial standpoint, it establishes something essential: proximity and awareness. Any serious case requires showing that a person was positioned to know what was happening, that they had access, and that a relationship existed, and these documents do exactly that. They also weakened Trump's long-standing claim that he barely knew Epstein, that he cut off contact early, and that he was never involved, because flight records, guest lists, and phone logs are the kind of evidence that cannot be reshaped by narrative and are now part of the public record. When compared to how the Justice Department has handled other high-profile cases involving powerful individuals accused of sexual misconduct, a pattern emerges. Once evidence links someone to a criminal network, even indirectly, prosecutors begin assembling a conspiracy framework. It is not necessary to prove that a person committed every act themselves, only that they participated, benefited, or knowingly remained involved. The deleted post becomes part of that picture because it suggests knowledge, showing that Trump understood what these documents contained and recognized that his denial would not withstand scrutiny. This moment extends far beyond a single controversy because it tests whether the rule of law truly applies to former presidents. Trump has repeatedly claimed protection through presidential immunity, executive privilege, and absolute authority. But the Epstein documents concern behavior alleged to have taken place before, during, and after his presidency, placing them outside any shield of immunity or privilege. If federal prosecutors or the Southern District of New York chose to act, the legal route is open. What makes this especially risky for Trump is that Epstein is dead, Ghislaine Maxwell is imprisoned, and other potential collaborators have either cooperated or disappeared from the spotlight, leaving one unresolved question at the center. Who else was involved? That question creates pressure and leverage, and prosecutors understand its power. Trump is already confronting 4 major criminal cases involving classified documents, January 6th, Georgia racketeering charges, and New York fraud allegations, and adding Epstein-related scrutiny would introduce a 5th investigation tied to one of the most explosive areas in American politics, crimes involving minors. No prosecutor would pursue such a case unless the evidence were overwhelming, but if the documents support it and witnesses confirm it, the legal terrain shifts dramatically, and Trump appears to know this. That is why the deletion matters, because the most basic advice any competent defense lawyer would give is to remain silent, neither confirming nor denying, and never creating additional evidence. Trump did the opposite. He spoke, then panicked, then erased his words. That is not the conduct of someone confident in a clean defense, but of someone who has just recognized genuine exposure. The reality many do not want to face is that the Epstein files are not disappearing. The documents are now public, legal scrutiny is intensifying, and Trump's erased statement has become part of the record. From a prosecutorial view, this is the kind of turning point you wait for when a defendant generates incriminating evidence on their own. This story is not finished. It is only beginning. And what happens next will reveal whether power continues to shield the powerful or whether accountability finally catches up, with more truth still to come.